Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County, October 1st, 2025. This is the civil bench trial and motions calendar, 10 a.m. Want to call the calendar. And the first case on the calendar is Tekeste versus 125 Fayetteville LLC and Jelks.
Judge, that's the 1 p.m. calendar.
Oh, I'm sorry. Progressives, not good. Here we go. All right, let's see if this works. Schamberger, Denisha versus Catherine Harrington.
Brandon
Yes, Your
Sardi.
Honor. Mark Stuckey on behalf of the plaintiff.
Good morning, Your Honor. Brandon Sardi on behalf of Prime Healthcare Foundation.
Brandon Sargent.
Sartin, S-A-R-T-I-N.
All right. Go ahead.
I was saying good morning. Hannah Johnson, court reporter for the takedown.
All right. Let me know if at any point you can't hear something or you need an adjustment, okay?
Yes, ma'am. Thank you.
All right. All right. So let me call the 10 rest of the 10 o'clock calendar. We'll go ahead and get started on the hearings. Wilmington Savings Fund, CVI, AMNR Investment Trust versus Gloria Figueroa. Anyone here on that? Ms. Powell, are they is that still a viable case, or did they dismiss?
It's still viable.
Okay. Once again, Wilmington Savings Fund versus Gloria Figueroa. All right. So unless we find different, either a lack of notice or some other issue, then that motion will be dismissed for warrant of prosecution. Alfonso Brinkley versus Omar Rashed.
Matthew Carlton for Mr. Brinkley.
Alfonso Brinkley.
All right. And Mr. Brinkley, I see that you're represented by Samuel Alderman and Roland Bridges. Roland, are they present?
No, I represent him, Your Honor.
Oh, I'm sorry. I meant Mr. Rashed. Mr. Rashed. Anyone here on behalf of Mr. Rashed? Okay. All right. And Larry Humphrey versus Daisha Thomas, Edible Arrangements, Cole Enterprises, Allstate Property and Casualty.
Good morning, Your Honor. Taylor Edwards here for the plaintiff.
Good morning, Your Honor. Charity Wood, behalf of Edible Arrangements.
Good morning, Your Honor. Keisha Knights on behalf of Allstate.
All right. Serge Alexander versus Zara Anderson and Dondre Taylor versus United Financial. So this is an accident with a cross claim.
Yes, Your Honor. Zan Patorgis and Peggy Rice here for the plaintiff.
And Kyle Waddell on behalf of Mr. Taylor.
Okay.
And
anyone
Carl
else?
On behalf of defendant Anderson.
And Kimberly Fussell and versus A Beautiful Mind Psychiatric, Charmaine Wilson and Wilson and Associates. This case was continued. The next case is Pierre versus Edward Brown and A&J Security. Okay, this was a motion for summary judgment. It was withdrawn. The parties were excused. Minor Moore, Ernest Moore, Adela Trejo, Fabiola Trejo versus Crestbrook Insurance.
Judge, they also withdrew their motion.
And James Lee Jean, Future Management Corporation, Delta Star Corporation. Is that part of that, that same case? Yeah.
Yes, ma'am.
All right, so let's get started. Schamberger versus Harrington. This is a medical malpractice claim.
Yes, Your Honor.
All right, I'm ready.
Okay. Your Honor, this is defendant's motion to dismiss. This is a narrow 12B6 motion. We're asking the court to dismiss only plaintiff's ordinary negligence claims. As pled, plaintiff's ordinary negligence claims require clinical judgment, so they sound in professional negligence. Plaintiff's professional negligence claims are not at issue here today. In Georgia, when a negligence claim requires clinical judgment in either the duty or breach element of the claim or the causation element, the claim sounds in professional negligence. Here, plaintiff has alleged that Southern Regional Medical Center's nursing staff failed to notify the NICU that a C-section had been ordered for plaintiff. Plaintiff further alleges that this ultimately delayed the C-section and caused the death to plaintiff's child. Secondly, plaintiff contends the failure to notify the NICU resulted in infant bed warmers not being present in the operating suite when the C-section was ordered. Here, Your Honor, these allegations clearly require medical judgment and involve medical questions. Whether a labor and delivery nurse needs to consult with the physician or staff in another department is a medical question that requires medical judgment. When weighing this decision, a nurse must consider a patient's clinical condition, and they must determine who needs to be involved in the patient's care and when they need to be involved in the patient's care. This process clearly involves medical questions that require medical judgment. As to plaintiff's second allegation, determining whether infant bed warmers must be in the operating suite is also a medical question that requires medical judgment. And certainly, Your Honor, as to both allegations, the causation elements undoubtedly require medical testimony for the jury to assess the claims. Here, plaintiff relies on the Dent case. However, this reliance is misplaced. Dent stands for the proposition that if a physician exercises his or her medical judgment and instructs a nurse to execute or carry out that instruction, and the nurse fails to do so, it is deemed to be ordinary negligence. Here, that is not the fact pattern. Because these counts as pled require clinical judgment, they sound in professional negligence. And therefore, we respectfully request that the court dismiss plaintiff's ordinary negligence claims under a motion to dismiss standard. To the extent that the court converts this to a motion for summary judgment, given that plaintiff introduced evidence beyond the pleadings, plaintiff's claims must be summarily dismissed because plaintiff has failed to show that there is a genuine issue as to whether the nursing staff were instructed to carry out the allegations that plaintiff alleges that they failed to do. Thank you, Your Honor.
All right.
Your Honor, Mark Stuckey on behalf of the plaintiff. We are at the motion dismiss phase. So, of course, all we have to do is show that there's some set of facts somewhere, and the motion has to be denied. And we have numerous professional negligence claims. Counsel already referred to those. So even if this motion was granted, the case will still be progressing forward. But the two instances of ordinary negligence are pretty clear. The first one about not having baby warmers in the labor and delivery OR, where babies are delivered, was discussed by Ms. Jarrett, who was the labor and delivery nurse. We quoted her deposition testimony in the brief. And those warmers are supposed to be there, good to go, for whenever there's a C-section. Because if there's no baby warmers, you can't have the C-section. This is not in dispute. And instead of having two baby warmers, because there were twins involved, there was only one, and the one that was there wasn't even working. And this resulted in a delay while they had to get two baby warmers. Now, we rely on the Dent case specifically for this because Dent said, which we quoted in our brief, and I'll quote it here, The failure to operate equipment correctly or in accordance with the doctor's instructions, or to keep certain equipment on hand, is only ordinary, not professional negligence. Moreover, the allegation that the nurses failed to ensure that the crash cart was equipped for pediatric patients is one of ordinary negligence. So the failure to have proper equipment for the C-section, we believe, is ordinary negligence. It's an administrative task, and therefore the motion should be denied on that ground alone. The second issue for ordinary negligence is the calling of the NICU. When the call went out for the urgent C-section at 5:50, calling the NICU does not require discretion. It's not that anyone has to sit there and think about it. One of the first things the charge nurse does when the C-section call goes out is they call the NICU. Because if there's no NICU staff in the OR, there's no delivery happening. It doesn't matter how fast the doctor moves. So there's no discretion involved in this. And it shows that the call went out at 5:50, but then according to the NICU's own note, they were not contacted until 6:10, 20 minutes later. And Ms. Jarrett, the labor and delivery nurse, in her deposition testimony, which is quoted in our brief, discusses the fact that they are literally standing around waiting to do delivery, waiting on NICU nurses. And we have expert testimony addressing causation, which discusses the fact that that delay of various acts resulted in the death of one of the twins. But it is undisputed that that call should have gone out as soon as the call for the C-section was made by the doctor. It didn't happen for 20 minutes, and that resulted in a delay in the delivery. We think these are not one, but two instances of ordinary negligence, and as such, the motion to dismiss ordinary negligence claims only should be denied.
Your Honor, if I may. Plaintiff is arguing that the nursing staff failed to adhere to the standard of care. He's essentially arguing that the standard of care required the nurses to notify the NICU when the C-section was ordered. Ultimately, though, however, and the same holds true to his allegation that the bed warmers needed to be in the operating suite prior to performing a C-section. That is a medical question. A layperson cannot determine whether or not a C-section, bed warmers must be in the operating suite before a C-section begins.
So, Mr. Sarton, let me ask this. So, assuming an ordinary operating procedure, we don't even have to deal with peds or NICU, but an operating procedure. So, before the surgeon walks into the operating room, somebody's required to stock the operating room with the necessary surgical equipment, with the necessary rescue equipment, with the necessary equipment for anesthesia and all of those things, and equipment for if something goes wrong, the doctor doesn't have to walk down the hall to get something to resuscitate or to get medicines that are necessary in an operation to correct something going awry, but everything should be there. Whose job is that?
Ultimately, Your Honor, whose job that is and whether that duty falls within the standard of care in this particular clinical scenario is a medical question. And ultimately, I'm not sure there's a clear answer as to whose job it is, which is why it's a medical question. Plaintiff hasn't presented evidence in which that state Southern Regional mandates that when a C-section is ordered, the NICU is notified. That has not been the evidence that he presented. Ultimately, the evidence that he presented is that one of the nurses said that typically the charge nurse notifies the NICU after a C-section is ordered. As to when they need to be notified is a medical question. And ultimately, he's making a standard of care argument. But nonetheless, Your Honor, even if this court is convinced that the duty and breach element of these claims fall within ordinary negligence, clearly causation is the causation element sounds in professional negligence. And Your Honor, there's a case by the Georgia Court of Appeals, Patman, that stands for the proposition, even if the duty breach element do not fall within professional negligence, if causation does, then ultimately the claim is a claim for under professional negligence. And in that case, Your Honor, in Patman, the actor at issue was a lab technician. A lab technician does not fall within the purview of 911 9.1. Here, our nurse is within the purview of 911.9.1. So clearly, our case presents stronger evidence that these are professional negligence claims and should be dismissed.
Okay. Mr. Stuckey?
Your Honor, in Patman, what the court said, and I'm quoting from the case, from the Patman case, which was brought to my attention when they filed their reply brief yesterday at 5 o'clock. They stated, quote, "They were exercising an independent medical judgment that required them to evaluate Mr. Patman." And they said the issue in the case wasn't simply a matter of whether the tech should have called a nurse. The question was, quote, "whether BJC employees should have recognized that this was a medical emergency, whether they proceeded correctly given the medical situation, whether they should have called the lab to ascertain the whereabouts of the blood, and or advised the lab that Mr. Patman's situation was urgent." And this is all referencing what the nurses should have been doing.
Yeah.
That's about professional judgment. Stocking, making sure there's equipment in the OR is an administrative task. That's what the key is on ordinary negligence. Is it just an administrative task?
Yeah, Mr. Sarton, I'm sorry to interrupt, Mr. Stuckey. Mr. Sarton, so I'm trying to follow the timeline from what your proposition is, and I'm trying to follow the timeline from what Mr. Stuckey's is. And so when a doctor determines that there's an emergency that would require a C-section, then orders go out to everybody. Get the OR ready. Let's make sure that, we have her blood type. Let's make sure anesthesiology is called. And this is all stat. Okay. So at that point, everybody has their marching orders, whether they're explicit or intrinsic in what they do. So if the nurses always go down the hall, make sure there are bed warmers, call the charge nurse calls and said, "Hey, we got a emergency C-section coming. Let's make sure there are warmers. It's twins." Was there a failure to advise that there were twins? Where was the failure?
Your Honor, plaintiff is alleging that there was a delay in notifying the NICU, not that
I get that there was a delay, but who's like I said, when the doctor says emergency C-section, at that point, everybody moves. And so where was the delay? Whose job was it to say, "Hey, we need an OR stat, it's a twin delivery, it's emergency C-section, and we're gonna need boom." So we're saying that the failure came when the charge nurse failed to do it in a timely manner.
Yes, Your Honor, which is a medical
every
question.
consequence of the failure of this, the decedent's demise was a result of that delay.
Yes, Your Honor. Okay. And whether or not the call was timely is a medical question. We have expert testimony that, and our expert will say that.
But she wouldn't have had to consult another clinician to either decide to make the call or not make the call. That would have been part of what she does every time she makes every time there's an emergency C-section. This is the protocol. You call and you call immediately. So if she went to the bathroom before she called, or she went down the hall before she called, that to me sounds like she wouldn't have had to consult a clinician to make the determination about whether to call. The call is something that's intrinsic in her duties.
And the point that defendants are making, Your Honor, is not that the charge nurse needed to consult someone in order to make the call, but when it was his determination as to when it was clinically appropriate to make that call. He has a whole host of responsibilities when a C-section is called. It's not only to notify other departments, it's also to help provide care, get respiratory therapists in the operating room, several different options. And it's his clinical determination as to when the NICU should be notified and if they need to be notified. That is defendant's argument. And Your Honor, we'll have expert testimony that will suggest that the obstetrician who was performing the C-section could have moved forward with the C-section without the bed warmers being in the operating room. We have an expert obstetrician who will testify to that. And so defendant's argument is that whether or not the bed warmers even needed to be in the operating room is a medical question that requires expert medical testimony.
Okay.
Well,
So So to me, then if the nurse's actions are determined to be ordinary negligence, we still maintain that the doctor deciding to wait for the warmers or not wait for the warmers is the professional negligence. Can't the court look at it that way?
I'm not sure. I'm not sure how you can separate it because ultimately,
Because it's two actors. And so if the nurse's job is to make sure these calls are made, then, and that's, nobody has to tell them, Mr. Rice, I'm gonna need you to.
I appreciate it.
Nobody has to tell them what to do because you're the charge nurse. You know what happened. When I say emergency C-section, OR, certain things are intrinsic in your training. You have to call the OR and make these things happen. So if you delayed in calling the OR, that might be ordinary negligence because you made that decision. You didn't have to consult a clinician. You didn't have to look at the guidelines. You just had to pick up the phone and make the call. Whereas if the surgeon in the operating room makes the decision to delay based on the fact that there are no warmers, the C-sections go fast. Just disclosure, I'm a survivor of an emergency C-section. And so they go fast, really, really fast. And so if the doctor delays in the emergency room, can't you have two separate incidents? You have the ordinary negligence that would have been the nurse delaying in making the call because you didn't have to consult a manual or any clinician, or she didn't fail to evaluate any kind of clinical data. She knows emergency C-section, I make this call. But then the surgeon in the emergency room, that can be a separate incident, which can be ordinary negligence here and professional negligence here, which would mean that both of the claims would survive on the part of Mr. Stuckey's client.
and defendants would argue, Your Honor, that the nursing conduct at issue here sounds in professional negligence because ultimately the question as to whether there was a delay in notifying the NICU is a medical question. It's a medical question as to when the NICU needed to be notified and when the bed warmers needed to be in the operating room. A layperson cannot answer that question. And there's been no evidence that there is a strict instruction from either a physician or the hospital for the charge nurse to immediately notify the NICU upon the ordering of a C-section. So therefore, it's within his clinical judgment to determine when he must make that notification.
Okay, Mr. Stuckey?
I mean, two things, Your Honor, just so it's clear, there are numerous delays in this case. There were numerous delays before the whole call went out for the C-section. Well, there's lots of professional negligence beforehand involving Ms. Jarrett, the labor and delivery nurse, whether she gave proper information to the OB, whether she delayed in notifying the OB. There's lots of professional negligence delays as well. These two that we're talking about are in addition to those. Okay, this is when I said that even if this court were to grant this motion, the case still goes forward pretty much as is. But these two instances, because they involve administrative tasks, that's ordinary negligence. And that's what the Supreme Court has said. Is this an administrative task? Just because it's a nurse, just because it's a doctor,
Right,
doesn't make it professional. And whether or not that room is stocked, I mean, the staff was very clear that that operating room in labor and delivery is ready to go at any moment. It is like 10 feet away from all the suites. And literally, you roll folks in and everything is there, good to go, because that's what they have to do, obviously, sometimes. So that's not a thing of anyone has to consult anybody. It's just part of your job duty to make sure this room is stocked every single day. And they've known for over a week that Denisha had twins. So they knew that there had to be two bed warmers. And instead, there was only one, and that one wasn't even working. So administrative task number one that failed. Two, as you pointed out, when the call goes out for an urgent C-section, there is no discretion about calling the NICU. It's not like the OB said, hey, I'm going to do a C-section today, so I'm going to do it whenever. And then they can call the NICU at 1 or 3 or 4 or 5. It doesn't matter. Everyone knows you have an urgent C-section. You call the NICU right then, right there. And that's, again, didn't happen for 20 minutes. So,
Mr. Sargent, I'm just really having a hard time making this a clinical issue as opposed to an ordinary negligence issue. And I'm getting several scenarios in my head. And because I'm thinking, if a doctor says to a nurse, okay, watch this patient, if they begin to have seizure activity, then you're going to give them the seizure medicine, but you're to monitor them, and you've got to make a determination about whether they're having a seizure. If they're having a seizure, I've already ordered the medicine, and you can give it upon your clinical evaluation that a seizure activity is present. Now, that's one thing. But if the doctor says, if the doctor doesn't tell her anything, but she knows it's her duty to go in there and, periodically check on, she has a certain amount of time that needs to elapse before she goes in and checks on a patient, and she fails to do it, or there's too much time in between, that's not a clinical determination.
Well, here, Your Honor, the charge nurse is not explicitly or intrinsically required to notify the NICU every time a C-section is ordered. I mean, there are some.
Who does?
It's a clinical determination by the charge nurse to determine who needs to be in the operating room when a C-section is ordered. That's the clinical determination. His job is to notify the appropriate personnel. Every C-section wouldn't require an admission into the NICU.
Okay, we don't know that though. See, here's the thing, because every C-section might not require, but you don't know that until you're in the C-section. This is the determination. But so when a charge nurse is told, C-section, get the OR ready, make the call, they're not charged with determining whether this C-section might end up with a child that needs to go under the NICU care. They just have to determine to open the OR or to tell whoever's supposed to be there to go to the OR. They don't get to determine the end game. They're just there at the start. Emergency C-section, OR, that's it. They don't get to make a determination whether NICU gets involved or not involved. In any of these situations, if it's an emergency C-section, NICU that's a default. NICU's going to be involved. They may not be needed afterwards, but they're going to be involved, because the possibility with an emergency C-section, that's the default. NICU needs to be notified because that's the default. And so for her, she doesn't have to make a clinical evaluation. She just has to call the people on her list to call.
Well, Your Honor, I think that the evidence in this case, and based on the pleadings, there has been no suggestion that the charge nurse was required to notify select people, and he failed to notify those select people. Here, the allegation is that
how does that become professional negligence? So you're saying there was no negligence. If she had no duty, then there's no negligence.
I'm not saying it's not professional negligence. I believe it.
Well, you just said she's not required to do anything. So if she's not required to notify anybody, she's not even required to make an analysis of whether anybody needs to be notified, which would be the difference between the ordinary negligence. I'm required to do this as a part of my duty. It's administrative. All I have to do is pick up a phone and call. Or the professional negligence, let me make an evaluation of the data that I'm getting about how sick or not sick that this patient is before I make this action. And so if you're saying that it wasn't even her job to do anything, she had no duty, then why does it sound under either ordinary negligence or professional negligence?
Yes, yes, happy to explain. So ordinary negligence, the only way this case could sound an ordinary negligence is if the charge nurse had a specific instruction to notify the NICU and failed to do so. Under the professional negligence standard, what plaintiff would argue is that the charge nurse did not act as a reasonable charge nurse would and failed to properly evaluate the situation. And that is the correct analysis in this case under defendant's theory, that plaintiff is arguing that the charge nurse should have a reasonable charge nurse would have better assessed the clinical condition of the patient and would have notified the NICU in a more expedient fashion, and ultimately that would have impacted the baby's survivability. That is the correct analysis in the case. There has been no evidence in the pleadings or throughout discovery that suggests the charge nurse received specific instruction either from the hospital or the physician to notify the NICU. And plaintiff's reliance on the Dent case is is misplaced, Your Honor. The Dent case doesn't simply say that the nurse failed to have a crash cart stocked. It says that the nurse was instructed to have the crash cart stocked and failed to carry out that instruction. This is not an administrative claim, Your Honor. This is a determination of clinical judgment. And again, Your Honor, I must emphasize, even if the court finds that the duty and breach element of these claims sound in ordinary negligence, the court also has to analyze the causation elements of the claim. Therefore, the plaintiff would be required to bring expert testimony to make the causation argument that the failure to notify the NICU in a timely fashion ultimately contributed or caused to the twins' death. And therefore, these claims clearly sound of professional negligence. A layperson cannot determine whether or not the delayed order of C-section actually caused the death. They need expert testimony.
That part, Mr. Stuckey.
Your Honor, we have expert testimony that said the delays, of which there were numerous, resulted in the death of Daryl Coleman. There were numerous delays. Some of them were due to professional negligence. Some of them were due to ordinary negligence. I mean, they simply said the delivery happened at 6:30. Okay, and at 6:30, Daryl was delivered deceased. If that delivery had occurred before 6 a.m., then Daryl would have survived. And we have an OB and a neonatologist testifying to those facts. Now, whether or not that delay was caused by ordinary negligence or professional negligence, that doesn't really affect that. I mean, they're like, if the baby is delivered half an hour sooner or more, the baby lives. Now, what caused that, whether it was ordinary negligence, professional negligence, I mean, the jury will sort that out. We have lots of negligence from the nurse before we even got to the call to the C-section. I mean, we had 50 minutes of delays from the labor and delivery nurse failing to respond appropriately and in her discussions with the OB. This part is a very small little faction of the case, and it's just about the OR was not stocked, and it was also about the fact that the charge nurse did not call the NICU timely in an urgent C-section situation, which is not one of discretion. It's not one, there's a debate. It's an urgent C-section. You've got to have the NICU there. And that wasn't done for 20 minutes. And the key is the Supreme say it's administrative tasks. And we're talking a delay in making a phone call and a delay in making sure that checklist for the OR wasn't followed. I mean, that's all it is, because there is a checklist for what needs to be in the OR at all times, and they simply didn't do it.
Well, Mr. Sarton, by the time we get to trial and this goes to a jury, the instructions are that there can be several causes of an injury. It can be more than one thing that contributes to an injury or damages. So in that case, even though it would take probably a clinician to determine all of the different causes that may have resulted in the death, the fact that it was ordinary negligence versus professional negligence, it means that you can consider all of them in the context in which they sit, as opposed to having to get rid of ordinary negligence because the causation piece would require a clinician to determine which factors contributed to the death.
Well, Your Honor, the Georgia Court of Appeals reviewed a case with a very similar fact pattern. And again, the actor at issue in that case, well, let me walk back. The trial court in that case granted defendants motion for summary judgment. Plaintiff appealed. The Court of Appeals reviewed that case. The fact pattern in that case is that the actor was a lab technician who was not regulated by 911-9.1. Therefore, clearly on the duty and breach elements of the claim, it sounds in ordinary negligence. The court held, however, that plaintiff's claim wasn't that the lab technician simply failed to notify the ICU when the blood was ready. They said that what plaintiff was arguing was that the failure to timely notify the ICU ultimately led to the patient's death. And that is a medical question. And therefore, this is a very similar fact pattern. But however, our case is even stronger because the alleged actor in our case is a nurse who is regulated by 911-9.1.
All right. Anything else?
Nothing further from defendants, Your Honor. Thank you.
Okay.
Nothing
right.
from the plaintiff, Your Honor.
All right, so the court will make a determination and we'll get an order out as quickly as we can. I understand folk want to have their day in court. All right,
Thank you.
thank you.
Thank you, Judge. May we be excused?
Yes, you may. Take care.
Thank you, Judge.
There's just one person in the courtroom. I'm not sure. I think it's a pro se defendant.
Okay, can you get the deputy to chat me about who it is and for which case?
Yes.
All right, thank you, ma'am. All right, the next case is this was the one that was dismissed. So Wilmington Savings and Figueroa. I didn't get a response from that. Mr. Brinkley, Alfonso Brinkley versus Omar Rashad. Mr. Brinkley is present. Mr. Rashad, anyone here on behalf of Mr. Rashad? All right, I'm ready to go forward with Mr. Brinkley's case.
Thank you. Would you like me to swear the witness?
Yes, please.
Alfonso, please raise your right hand. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right. Mr. Brinkley, you entered into a contract with Mr. Rashad to provide home renovations. Is that correct?
Yes, sir.
All right. And included in that was you installed a bathroom tub, you build a subfloor, heat and air, electrical, exterior, build platform, build a box frame for the tub. Explain briefly to the judge exactly what you did for this work.
Well, Your Honor, at first I started off in his basement where I connected the hot water heater to create a kitchen, which electric stove, sink, and a countertop and cabinets. And we came off the water heater to install that. That was completed. We also went out to the back unit and we installed a bathroom, which was in an outhouse. We created running water. We created a water heater. We tapped into the existing water that was ran to that back house, to that unit. And we created a tub, a washer and dryer, and a sink, and we put in a subfloor. All that was created and done properly.
How old was the house?
I'm not sure the age of the house, Your Honor.
It was not a new build though, or nothing recent that you were just upgrading.
It was something that he purchased that someone else had placed those running waters to that outhouse that on. It was like I guess an addition to a back, maybe a garage or something, but they created it out of a bedroom and made it a livable space with a front door.
Okay.
And how long did you take to do this project?
He had about, I think it was maybe 5 projects. He paid me on all the projects up until the last one. It took me probably about 6 months, 8 months off and on.
So what was the specific last project that he didn't pay you? Is that the one you were talking about just a moment ago about the outhouse?
Yes, that was the back outhouse that he created a tub and a wash and dryer and a wash bowl.
All right. And how much are you seeking for non-payment? Your complaint says $15,000, your statement of claim.
Yes, that's the amount that he owed me for the uncompleted work, for the work that was completed that he didn't pay.
He did pay for the work completed, and was that approximate? How much was that approximately?
Well, it was like 3 different invoices. Let me get it. It was 3 different invoices that he paid me on. He paid me one invoice that was $2,575 that he paid. And another invoice was $8,035 that he paid. The other invoice was $9,510 that he paid.
Did he ever give explanation as to why he wasn't going to pay the final bill?
No, he didn't. We set up a payment arrangement because of he was paying me as the job was completed. So we set up a payment arrangement for the last invoice, and he only paid $1,000, and then he sent me $1.
Okay.
At that
So you're
point,
asking the court right now for 15,000 for the work you performed that have not been paid?
yes.
All right. That's what I have, Your Honor.
All right. Last question. Was this going to be rental property or was he living there?
I'm not sure. He was living in part of the house, Your Honor, and he was living in that back area. The front area was I think it was a 3-bedroom, 2-bedroom downstairs, and 1 unit upstairs. So I believe, I can't say for sure if he was doing it to rent those areas out.
All right. Well, sir, Mr. Rashad has not appeared to challenge anything that you have stated. The default was granted, and at this time, the court is going to grant you the payment of $15,000 plus court costs on the contract.
Thank you, Judge.
You're welcome, sir.
Thank you, Your Honor.
Bye.
Take care, Mr. Brinkley.
Thank you. I can be excused.
Yes,
Yeah.
sir.
Thank you.
All right. Humphrey, Daisha Thomas, Cole Enterprises, Edible Arrangements.
Good morning, Your Honor. Taylor Edwards for the plaintiff.
Good morning.
Good morning, Your Honor. Charity Wood for Edible Arrangements, and it's my motion.
Good morning, Your Honor, and Keisha Knights here for Allstate.
Allstate. Okay.
All right. Your Honor, this is a car accident case. Mr. Humphrey was driving his vehicle with a trailer attached. Miss Daisha Thomas, she hit his trailer, and from our perspective, it looks like she caused the accident. At the time, she was working for Cole Enterprises. Cole Enterprises is a franchisee of Edible Arrangements, and Edible Arrangements is the franchisor. That's who I represent, Your Honor. This motion is basically to get Edible Arrangements out because Edible Arrangements did not owe any duties to plaintiff. There was a contract in place, Your Honor, and I'm not going to regurgitate my brief.
Right.
It was a contract in place. Cole Enterprises was an independent contractor, and Edible Arrangements simply didn't owe any duties to plaintiff, Your Honor. And this lawsuit was brought against both entities, and of course, Daisha Thomas defaulted, Daisha defaulted, and we're kind of stuck here. So we're asking you to dismiss it.
Okay. All right. Yeah. So just so I'm clear. So
Your Honor, I can't hear you well.
I'm sorry. Is this better?
Yes, ma'am. Yes, Your Honor.
Okay. I think I was leaning again away from the microphone. So essentially, businesses are starting to do this where they will hire a third party to deliver on behalf of their business, but they're not in contract with the person who's ordering, other than they make the order and then we're going to contract the delivery out to a third party. That's my understanding as to what was going on here. Is that correct?
No, Your Honor. Cole Enterprises was actually a store. So they're a whole standard store, and they hired
okay, so they franchise the Edible Arrangement name.
Yes, Your Honor.
Okay, and then they're running their franchise, but Edible Arrangement, the corporation, the mother corporation is not involved. That's the argument. Okay. Go ahead, Mr. Edwards.
Your Honor, I actually did not file a response to this motion and just wanted to get the court's opinion on it, on defense counsel's arguments. We don't have any, I won't say we don't have any objection, but we won't place an objection on the record. We don't have any rebuttal. And we do have we have the UM carrier that's here, the counsel for UM, Ms. Keisha Knight, she's on. And so really, I think it's going to end up just between us. And so I'm just waiting on the court to make it.
Ms. Knight, did you have a dog in this fight?
No, Your Honor. It doesn't appear that there is any tort in front of us, especially if Edible Arrangements is released, and we're prepared to move forward as UM if that's the case.
Okay. All right. Well, it sounds like it's pretty cut and dry. Cole Enterprises seems to be the the entity that is involved, as opposed to edible arrangements, which is tangentially at best. And so we'll go ahead and make and issue an order so you all can move forward with getting this resolved. Because I don't think this is going to go to, it doesn't sound like something that's going to go to trial. It may, but it doesn't sound like.
We never know, Your Honor. I think part of the issue not to go too far into it, but part of the issue is that Cole Enterprises is in default. For one, the driver also is in default. So we don't have either one of them involved in the case.
Yeah.
And also Cole Enterprises did not have any coverage at the time. So yeah, that puts plaintiff in a position. So we are looking forward to hoping getting this resolved with the UM carrier.
I get frustrated because I want businesses to act in a business-like manner, and that involves a lot of different moving things, but I get it. So, all right. Well, ladies, it's been a pleasure. If you end up in my courtroom, I look forward to it.
Thank you, Your Honor. Have a good day.
All right. You too. Take care.
Thank you.
All right. Serge Alexander, Zara Anderson, Dondre Taylor.
Yes, Your Honor. Kyle Waddell on behalf of Defendant Taylor. It's my motion.
Okay.
Good morning, Your Honor. Jim Rice on behalf of the plaintiff, Serge Alexander.
All right, sir, go ahead. You can begin on behalf of Mr. Taylor.
Thank you, Your Honor. This is another car accident case. My client was driving for Lyft on the rideshare platform. He picked up Mr. Alexander, the plaintiff, as a passenger, and they were on the 75-85 connector in the early morning hours when an accident occurred. And there was a tire that got loose on the roadway. Some vehicles responded to that tire. Mr. Taylor was driving down the connector when he saw this begin to happen. There was a vehicle ahead of him and to his left that started to slow down and ultimately merged over into Mr. Taylor's lane. The only evidence in the record on when Mr. Taylor began to brake is that he did that before that vehicle got all the way merged over in front of him. Ultimately, Mr. Taylor slowed down and was able to avoid hitting that vehicle that was slowing in front of him, and was struck from the rear by a co-defendant, Ms. Anderson. Ms. Anderson has admitted that she could have avoided the accident if she would have been able to slow down sooner to do so. She admitted that she noticed Mr. Taylor's vehicle slowing down and just couldn't get stopped in time. Mr. Alexander, the plaintiff, agrees that Ms. Anderson was following him too close. And if she would have kept at least a car length, then the accident may not have happened. Plaintiff nevertheless contends that Mr. Taylor was negligent in this case for somehow failing to brake in a manner that would prevent Miss Anderson from running into it. Mr. Taylor has dash cam in his vehicle, and I can share that with Your Honor and take you through what happens. The pertinent events happen just after the 8-minute mark of the dash cam video. I've got it up on the screen. If you can't see it, please let me know.
I can see it.
We'll start just after the 8-minute mark. And they're traveling down I-85. In just a few seconds, we're going to see what happens. And Mr. Taylor sees vehicles in front of him begin to brake there. That vehicle begins to merge. The testimony is he's starting to brake at this point. You can see his vehicle slow down. And then you can see the bump when he's hit from behind. Mr. Taylor did everything that he is required under the law to do. He slowed down to avoid running into a vehicle in front of him. He safely maintained control of his vehicle, and he was hit from the rear. He simply did not breach any duty here. There is a claim in this case that Mr. Taylor somehow was not paying attention or waited too long to brake. The video speaks for itself. We've cited some law in our brief that says you cannot contradict clear video evidence when it shows you exactly what happened. And this video tells the tale. We've also got rear-facing camera video that we can show you, Your Honor. And this starts from about the same position There's claims that Mr. Taylor was not paying attention to the road. The rear-facing camera video here shows you that that's not the case. We can see Mr. Taylor's head in the bottom right corner here. He remains looking forward throughout the pertinent time period. You can see he's traveling down the road, keeping up with traffic. He begins to slow and other vehicles begin to move faster than he does. And then he's hit again. There's no evidence in this case that Mr. Taylor was not paying appropriate attention, that he did not safely maintain control of his vehicle, that he avoided the only thing that he had the power to avoid, which is running into the vehicle that was in front of him. Plaintiff wants to hold Mr. Taylor liable here because there's more coverage, and that's what he's after. But Mr. Taylor simply did not breach any duty in this case. And more importantly, Your Honor, even if a jury could find somehow that he breached a duty, there is no dispute of fact that anything Mr. Taylor did or did not do proximately caused the accident. There has to be evidence, not just speculation, that if he had braked at a different rate, the accident would not have happened. And there is no such evidence here. Mr. Alexander admits that he doesn't know whether Miss Anderson was paying attention. Miss Anderson says she saw Mr. Taylor slowing down and just wasn't able to brake. She admits that she cannot run into somebody that's in front of her. The simple fact is, Your Honor, Mr. Taylor did everything that he is able to do in this case to avoid an accident, and Georgia law simply does not permit somebody to be held liable under these circumstances. The video is clear, and if we start holding people responsible for not braking at a certain time to avoid people behind them running into them, I think that creates a very slippery slope. And there's simply no law in this case that would permit a jury to find Mr. Taylor was negligent or a proximate cause of the accident here. I'll answer any questions you have, and we've submitted briefs on the matter, and both of the videos are in the court's record.
All right. May I hear from Mr. Rice?
Yes, thank you, Judge. I would tend to agree with defense counsel if that was the evidence, and there is basically some things from Mr. Taylor that he just recitated that Mr. Taylor said. But the issue, Your Honor, is whether there's a question of fact based on the record evidence. And what wasn't provided to you was, for lack of a better word, the rest of the story. So what I'd like to do, if it's okay with you, is go through the testimony from the young lady that struck my client's, the car he was in from behind, which wasn't addressed, as well as the affidavit that was filed timely. And then the video, we have it because it's very hard when you're going that quickly. So the affidavit we filed yesterday that Mr. Patorgas will bring up in a few minutes, we can go through the little snapshots because it's not the way it was just presented to the court. What we've always presented as the cause of action, Your Honor, is not simply that one defendant or the other was at fault, but the cause of the collision was a combination of both bad actors in this case. It's accurate that Mr. Alexander was in the vehicle. He was going to relieve his daughter so he could babysit his granddaughter. And at that time, according to Miss Anderson, they were going about 60, 65 miles an hour. They approached these vehicles. There's no argument or contention that the tire contributed to the collision, and certainly not Mr. Alexander. But she was following too closely. Now, the issue isn't that what was repeated to you was that he slowed down appropriately. The only person that says he slowed down appropriately was Mr. Taylor. And what I'll give the court is
Mr. Rice, I guess I'm trying to get to the crux of the matter, because usually people are responsible for avoiding the accident in front of them.
Yes, ma'am.
Because you're supposed to be driving forward. Your rearview mirror is there to ensure that, if there's a hazard behind you, you can appreciate that hazard. But usually your duty is to avoid causing an accident, or to avoid the accident that is in front of you, where you might have the opportunity to, zig or zag or avoid it in some way. The second thing is, when you're driving, there's supposed to be a certain amount of space between you and the driver in front of you, such that even if they stopped on a dime, you would be able to avoid that collision because you're far enough away and you can appreciate what they're doing such that you stop with space between you. Now, that's generally how the rules of the road have worked as long as I've been driving. But now you're telling me that Mr. Taylor, who avoided the accident ahead of him, there was a clear hazard because he didn't see the tire. Like I'm watching the video, he sees the vehicle start to merge and stop, so he knows something's going on. But the tire then comes around the SUV that was in front of him. He avoided the tire. He avoided crashing into the SUV. He brought his vehicle to a stop with plenty of space between him and the car in front of him. The fact that he was impacted from behind make sense to me why he might have been at fault.
Yes, ma'am. That's not a problem. So the following two close statute, the rules of the road, Your Honor just referenced, applies to cars in front of you, but it can impact the cars behind you. So I agree with Your Honor that it mostly deals with cars in front of you, that you shouldn't follow too close and avoid hazards that are in front of you. But the rules of the road don't allow us, and what I can give the court the record evidence of is it doesn't allow us to drive for 4 or 5 seconds at 65 miles an hour, which calculated out as 500 or 600 feet. So 2 football fields, and then abruptly slam on your brakes. So it's not a situation, Judge, where we're saying he's 100% at fault and she's not at fault. And all we're arguing to the court is there's a question of fact. People get tickets all the time. It happens, if this isn't a fraudulent claim, but it happens all the time where people just slam on their brakes and cause a collision where there's no need to slam on their brakes. And that's what happened here. Everybody else slowed down normally, Your Honor. And the defendant, Taylor, said, and I'll cite to the court on page 42, she said that the combination of her following and him slamming on his brakes caused the collision.
He should have been prepared for him to slam on his brakes. He was prepared for the people in front of him to slam on brakes. They didn't slow down normally. They stopped. Like he's seeing brake lights, they're stopping, but at 65 miles an hour, you're not stopped. As one of my friends who's a judge says this, and it cracks me up because she says it about truckers. But you're expecting people to stop on a dime. They need a whole $5. At 65 miles per hour, you're not stopping on a dime. So you're going to have time. It's going to take you time to bring your vehicle to a complete stop. And when he did that, like the other cars in front of him, a tire comes around him. So at this point, the tire's on the ground. The cars in front of him are able to appreciate that there's a tire rolling around, but he can't see it until it comes around the car in front of him. So when you're saying everybody's slowing down, well, they see the hazard. He's slowing down because he sees red lights. He slows down with plenty of time space in between him. I just think that in a situation where this man avoided the accident, the collision that he could appreciate, to then put him in the crosshairs of a lawsuit because he has better insurance, when the lady behind him was the one who should have seen his headlights and should have had space between him. She's the bad actor here. Why are we putting him in the crosshairs of facing a lawsuit?
Well, first, that's always been Lyft's position about the amount of insurance, and that's one, not admissible. It's not true. The police officer found him at fault. Everybody but for, I think, lane change. So the police officer found him at fault. Ms. Taylor said he was at fault.
I'm sorry, did he change lanes?
Yeah, you can see him at the end, Your Honor. You can see him change the lanes. If you look, I can pull up the police report. It says right there he determined he was
okay. The police report means less to me than a video because the police are never on scene when these things happen. They only do what they're told.
And Your Honor, that citation was dismissed because Mr. Taylor fought it and was able to convince the prosecutors and the police that he was not at fault for causing the collision.
I mean, if you look at the video, police reports are worth what they're worth, but they're never on the scene. I've been on this bench 10 years, and maybe 1 or 2 police officers have been sitting on the side of the road when a collision happens. Very rare. But when they come to a scene, they take the information that they're given. But in this case, I'm watching the videos front and back. The gentleman did what I hope somebody would do, is avoid the collision. He could have been a part of 2 collisions.
And I don't mean, I'm not questioning you, but I believe where you're going with this, as I understand the court's current position, is your position is based on your understanding that as soon as he saw those brake lights, he also started to brake. And if that's the court's position, that's contrary to the evidence from Mr. Alexander, and it's contrary to the evidence. If you look at the video, you can tell from the video he does not start braking. And Mr. Alexander, in fact, Your Honor, if I could show you, or almost show you, Defendant Taylor on page 42 of his deposition was asked, from the time you saw the brake lights, when did you finally start braking? He said between 4 and 5 seconds, and at 60 miles an hour, Your Honor, that's almost 500 feet. So the reason that he's in the lawsuit is not because he started braking. The reason he's in the lawsuit is when you're following too closely under 4649, you have to adjust what you do and how far you follow vehicles based on the speed, the traffic, and the traffic conditions. So I don't know of any law that allows me to go 60 miles an hour. Everybody in front of me is slowing down because of a hazard he admitted he saw. And then right when I get near the end, I slam on my brakes. So we're not saying he's 100% fault, but everybody in this collision other than him, she very clearly said it on page 51 of her deposition, Your Honor. I mean, in terms of a question of fact, she very clearly said that the collision was caused by a combination of her following too close. I said, by your observation, this is to the other driver, he abruptly applied his brakes. Do you agree that at a minimum, he contributed to the collision? And her answer on page 51, line 20 was yes. So it's not that I agree we should all apply our brakes when we see that traffic lights coming up. And I just tried a case last week, and the accident reconstructionist explained that the perception reaction time is a second, sometimes a second and a half. His own testimony is he never touched his brakes for 5 seconds. That's why everybody's testimony is he slammed on his brakes. And we can't just go around, wait till the last minute. And we have if Zan, if you could pull them up, the still shots, and you can see that he is conversing with Mr. Alexander. When you look at the back and the front, you can see that, Your Honor. So I agree, it's not a situation, it would be a much different situation if we were here trying to say, well, you know, as soon as they put on their brakes, he put on his brakes. What in the world did he do wrong? 100% agree with that position. What's the record evidence says is no. And we cited the Fouts case where it said it's a jury question or the person's, I apologize, can give an opinion on that whole entire issue. So on Exhibit 3 that's shared up, you can, on the share screen, Judge, you can see these are at different timestamps. This is at 13, and then it gets to, if you pull up, it goes through each one as 14, 15, 16, 17, and 18. And then in the affidavit, the defense lawyer, Mr. Waddell, told you that the only evidence is that he applied his brakes within 2 seconds. Paragraph 8 of his deposition, part of the record, says he first slammed on his brakes, like everyone else said except him. He slammed on his brakes at 8:17, almost into 8:18, which is 100% consistent with the defendant's own testimony that he waited 4 or 5 seconds after even seeing it to even touch his brakes. So it really is a question of fact. And I understand, Your Honor, you may believe a jury will do one thing and we may believe a jury will do something else. 100%, you know, we've all tried a lot of cases, can see things going either way. But I believe in terms of a motion for summary judgment, if it's a question of fact, our client, Mr. Alexander, the co-defendant, all say he caused or contributed to the collision and he slammed on his brakes and he had plenty of time, including his own testimony. They had 5 seconds at 60 miles an hour. I just looked it up. It's almost 500 feet before he touches his brakes. And the law doesn't allow us just to go around and slam on our brakes. And she was, in my opinion, following too close. She denies that on page 29 of her deposition, but she was following too close. But if he had applied his brakes normally, and if he'd applied his brakes when all the other vehicles applied their brakes, not 5 seconds later, she could have applied her brakes too. That's the difference. You know, you live in Atlanta, we all live in Atlanta, we see people drive, you know, one or two car lengths are closer to each other. But if you see that Christmas tree start and everybody applies their brakes at the same time, there's no collision. When all of a sudden one person in that Christmas tree light decides to slam on their brakes, that's when the collisions happen. And that's what you're not allowed to do under Georgia law.
All right. Well, I don't like it, but I think there exists genuine issue of material fact.
Well, Your Honor, can I address that?
Yeah.
Because I think
Well,
some of the records
okay, I'm
been
gonna let
misrepresented.
you address it, but this is where I'm going with it. Just because I don't like what it says or agree with what it says, if somebody presents an evidence in the form of an affidavit or deposition testimony that says, hey, I know you've seen the video, but when I perceived it at the time, it appeared that he slammed on his brakes. And even though I know I was following too closely, I had to slam on my brakes and slid into him because he slammed on his brakes and he didn't stop when the other cars. So if that's the evidence that's in the record for my consideration on a motion for summary judgment, then I don't get to essentially determine the quality of the evidence. There's evidence that exists that from a reasonable standpoint, a jury could find in that direction. But go
I
ahead.
understand, Your Honor, and I'll clarify a few things. So Mr. Rice pointed to page 42 of Mr. Taylor's deposition when he was asked how much time went by, and he does not say, I waited 5 seconds to hit my brakes. He says, I want to say I have a degree of confidence I was under 5 seconds. You know, I want to say immediately, but I know there was some reaction time. I'd have to watch the video again, but I think it was around that time. He testifies later in his deposition that he began hitting his brakes before the vehicle in front of him merged into his lane. That's 2 to 3 seconds.
Could you read the actual question, Kyle, beginning on line 2 of page 42? Because that's exactly what I do ask him.
But remember, the question itself
Do you know
is not
how much
evident.
time? Correct. That's exactly right. Do you know how much time went by between the first brake light going on in front of you and when you applied your brakes? And you can give me a range. He says, 4.5, 5 seconds, but I want to say I have a degree of confidence I was under 5 seconds from when I want to say immediately, but I don't know. I know there was some reaction time. So I want to say about, 5 seconds. He clarifies later in his deposition. And because it was several car lengths in front of you, were you already applying your brakes at that point, or do you know when the vehicle in front of him began to merge? He says, yes, I was already applying my brakes before that. We see from the video that happened within 2 or no more than 3 seconds. Okay? Ms. Anderson's testimony. Ms. Anderson's testimony talks about, she was asked about whether Mr. Taylor began to abruptly stop in front of you. And when he did that, did you immediately apply your brakes? She says, I was already applying my brakes because I could see, I couldn't see something going on, but I just felt like there was something going on because he was moving a little bit slower. So she knows he's already slowing down before he begins to apply his brakes. She knows he's slowing down. That's what the record evidence is. And Your Honor, perhaps most importantly, nobody can contradict or create an issue of fact by contradicting the video in this case. And we cite the case in our brief. I'll find it for you here in just a minute. But there's good Georgia law that holds you cannot create an issue of fact by contradicting what is clearly shown on the video. The case site for that is Vidal versus Leavell, 333, Georgia App 159 at page 161, note 2. When witness accounts differ, the court must rely upon facts as depicted by the videotape. Now, that case was overruled on other grounds relating to the collateral order doctrine, but there's also a U.S. Supreme Court case, Scott versus Harris, 127 Supreme Court, 1769. When opposing parties tell two different stories, one of which is blatantly contradicted by the record, so that no reasonable jury could believe it, a court should not adopt that version of facts for purposes of ruling on a motion for summary judgment. There's an 11th Circuit case that cites that says where video contradicts a plaintiff's version of facts, the court accepted the video's depiction of events when ruling on a motion for summary judgment. Your Honor, there can't be a dispute of fact when we know what happened based on the video. And as Your Honor has already pointed out, Mr. Taylor sees vehicles in front of him. He is able to stop with plenty of space to avoid running into those vehicles. And for him to wind up in the crosshairs of a lawsuit because somebody runs into him is not supported by any law that says he has a duty to stop at any other rate than what he did. He controlled what he could control, and he cannot be held liable because the driver behind him failed to stop and ran into him. As Your Honor has astutely pointed out, everybody's got a duty to not follow too closely and not run into the vehicles in front of them. Ms. Anderson has agreed with that, and speculating that maybe if he'd applies the brakes at a different rate, the accident wouldn't have happened is not sufficient to defeat summary judgment. You have to have evidence, not speculation, about proximate cause in order to defeat this motion. And there is no evidence that the accident would not have happened if he had braked any differently.
All right. Mr. Rice, Mr. Waddell says that the video evidence trumps everything else that is speculation on the part of the drivers.
Yes, ma'am. And I'm familiar with the case law he's referencing. In our video, the videos he's referencing, Your Honor, mostly deal with criminal conduct and things like that. In this video, the issue is where it's very clear. The issue here is, unfortunately for probably us and maybe for him, there's nothing that details speed or distance or anything like that. According to them, according to his own client, Mr. Taylor, it was 4 to 5 seconds when he read that question. When did you start to do it? When did you apply your brakes? And under prophecy, he stuck with that 4 or 5 seconds. So the question he referenced later is, when did you apply your brakes when you saw the cars merging in, which was after the brake lights for the court's information. But what's important is on the video, if you look at paragraph 8, which is Exhibit 5 to Mr. Alexander's affidavit, he affirms under swearing under oath that at 8:17, which again is 100% consistent with Mr. Taylor's own testimony, that is the time. So you're 8:13, 40, 5 seconds in. That's the first time he slams on his brakes. And other than Mr. Taylor's own self-serving testimony, which Your Honor has to look at skeptically under the law, not skeptically, but
I got you.
Yeah. Under that, the only person that says he slowed down appropriately is him. The video it's not clear. You can't see what he's doing the last 3 or 4 seconds of the rear facing video. You can't see when he slams on his brakes. We can only go by what he says here. And the plaintiff testified he slammed on his brakes. The co-defendant testified he slammed on his brakes. It was one of the first questions we asked at her deposition. The case that says you can do exactly what we're arguing, Your Honor, I'll cite to the court if it's okay. It's Fouts, F-O-U-T-S, the Builders Transport, Inc. And the site on that, Your Honor, is 222 Georgia App 568. And it talks about the questioning on the speed and whether someone could give an opinion. At the time you saw the brake lights, had the brake lights working, do you think he could have stopped? So that was what the Mr. Waddell was referring to as speculation about that. But then the appellate court goes on to say they objected to the question because it called for a conclusion, speculation, and was not a witness, knew how to answer. The Court of Appeals rebutes that and says it is well established that a lay witness may express opinions regarding traffic signals, speed, distance, and stopping distance based on the witness's observations. And then does a string cite, to a bunch of other ones. It says, under examination and to be decided by the jury shall be one opinion of one witness may swear to his own opinion or belief, giving the reasons therefore. It's long been the rule in this state, and where the relevancy or competency of evidence is doubtful, it should be admitted and the weight is left to the determination of the jury. And so that's all we're asking, Your Honor. It clearly might be a reluctant ruling by the court. We stand fit to try the case and see, what happens and where it shakes out. But, it's very difficult for me to imagine that 2 of the 3 people involved in the accident are going to blame or partially blame one of the defendants can't be right for summary judgment. And for those reasons, we respectfully request the court deny Defendant Taylor's motion.
All right, gentlemen, I will get you out in order.
Thank you, Judge.
Thank you, Your Honor.
May we be
Are we
excused?
excused?
You may.
Thank you, Judge. Have a
Thank
good
you.
day.
All right, so the next case I have is Fussell and versus Wilson and Associates, Charmaine Wilson. Do we have anybody on that case? Or is this the one that was withdrawn?
Continued.
Okay, continued. And then I have the next case, Pierre, that was withdrawn.
Yes, ma'am.
And the next case is Ernest Moore, Fabiola Trejo.
And this one was withdrawn as well, Judge.
Okay. All right, so that concludes the 10 a.m. calendar, 11 a.m. calendar.
Judge,
Yes, who do we have in the
yes.
courtroom?
Yes, can the courtroom turn on the camera, please? It's on, Judge. I'm not sure who that person is.
All right, come on up to the computer, please. In the courtroom. Come on up to the computer. Hola. 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 Do you speak English? Habla inglés? No. Ms. Val, can you see if Ms. Bermudez is available either by video or Ms. Tolles by video or to come into the courtroom?
Okay, I will.
Un momento, necesito interpretar. All right. All right, so first case on the 11 a.m. calendar is Citibank versus Sherry Newman. Citibank versus Sherry Newman. I saw Miss Newman. I saw Newman. Yes. Anyone here on behalf of Citibank? Mr. Richard? Are you here on behalf of Citibank?
I am not. I'm here on behalf of the Intent Suites.
All right. Anyone here on behalf of Citibank versus Sherry Newman? Ms. Powell, did you get anything for Citibank?
No, ma'am.
All right, so that case is going to be dismissed for want of prosecution. Ms. Newman, can you turn on your video and your sound for me?
Yes, ma'am.
All right, so Citibank, I'm not sure if you've been in contact with them, but the case against you at this time is going to be dismissed for want of prosecution because they're not here to advance their claims against you, okay?
Okay.
All right, so but I say this, Ms. Newman, it doesn't prevent them from trying to come back. So what you want to do is if you have information that counteracts the claim or that you can present on your behalf, gather your information and just be prepared for that, okay?
Okay, I have all my receipts and I'm continuing to make payments.
Okay, well, that may be why they didn't show up. All right then, ma'am. Thank you. You're free to go at this time.
Okay, thank you.
All right, take care. All right, next on the calendar, okay, the interpreter's on her way, and the
Number 2, is there an error, Judge?
okay, number 3 is Melford James Colley. This was withdrawn versus Crooks. This motion was withdrawn. And the next case is Forest Park, Georgia, OpCo LLC versus Daniel Jackson. Forest Park versus Daniel Jackson. Anything on that, Miss?
No, ma'am.
All right. Last call for Forest Park, Georgia versus Daniel Jackson. All right, that case will be dismissed for want of prosecution. All right. Next case is PNC Bank. I hate these classes. PNC Bank National Association versus Justin Brown. PNC Bank, Justin Brown. All right, that case will be dismissed for want of prosecution. All right, Midland Credit Management versus Christiane Thomas.
Good morning, Your Honor.
Good
How
morning,
are you?
I'm fine. Is there anyone here on behalf of Midland Credit Management? Midland Credit Management. All right, so yes. Ms. Thomas, no one has appeared on behalf of Midland Credit Management. This is, I believe, it says a contract case, which usually means a credit card case or some kind of debt. This case is going to be dismissed for want of prosecution. That doesn't mean that they won't try and come back. Okay.
Your Honor, may I speak?
I don't know if you want to. We're recording, and if you put stuff on video that they could use, you may just want to stand mute. And
no, I just wanted to say for the record that I was not in receipt of her motion. The plaintiff stated that she mailed me something out on August 27th. I never received the court date. And I submitted the affidavit as well as a motion to dismiss with prejudice. So because the plaintiff did not show up, I am requesting that it be dismissed with prejudice.
Okay, and what's your motion to dismiss with prejudice based on, ma'am?
And this would be based off of, I got notes, so let me go down my notes. One, because I wasn't properly served, that my process, the due process for me to actually go through the process of defending myself, that was violated for myself. The plaintiff has not provided a signed contract, and the documents that they provided was redacted. Everything was redacted, did not show me bearing proof that this debt belongs to me. And I did some research based off the FDCPA 15 USC 1692 E10 prohibits false or deceptive means to collect debt. And there's also another case with the same creditor in which I filed earlier before this one, and I have not gotten any information from this person as of yet. And when I submitted the affidavit of no receipt, I actually attached the case for that one just to put it in front of you.
Ms. Powell, can you check service on this for me?
Yes, ma'am. One moment. Okay, so they filed an affidavit of service on May 26, 2025 to the address of Hampton, Georgia 30228.
Did they say personal or notorious?
It was personal, confirmed identity and accepted paperwork.
All right, ma'am, they're claiming that they served you personally, that they handed paperwork to you in hand.
That was the very first one. That was the very first one I found out about what they were trying to do. But for me, they were supposed to respond. They didn't let me know that they wanted to respond with motion for judgment. They didn't notify me according to their certificate. They said that all parties received it. They sent it to me August 27th via mail, and you guys got it electronically. So I was not aware of the motion for judgment. this is what we're in court for today, right? The one she was trying to bring judgment against the case.
Okay, so she served you. So, okay, Ms. Powell, there's only one case, Midland versus Thomas. Is that correct? Can you check for me and make sure that there's not another case that I'm not aware of?
No, it's just.
Yes, ma'am. Give me 1 second.
I'm a little nervous, Your Honor.
Okay, so this is what I have to verify, that you've been served. And so Ms. Powell goes through the cases and verifies service. So she verified it, but I had her check it again. So what you're saying to me is a little bit confusing because you make it sound like there's more than one case.
Okay. All right.
But my understanding is there's only one case, Midland versus Christiane Thomas.
So there's actually two. There is two court cases.
Okay.
I was thinking, I was under the assumption that after I filed my response to me being served, that the attorney is aware of the documents that I sent to her and that she was supposed to come back and respond to me before it made it to court. So
no. So when a complaint is filed, the complaint is filed and served. So the summons and complaint gets served, and then you have the opportunity to answer. But unless there's a motion pending, there's no responsibility from that point for them to respond to your answer. At that point, you either go forward to trial or somebody files a motion or requests discovery. Now, if they haven't asked for discovery and you haven't asked for discovery, then the next thing would be a motion. If you get served with the motion, that's where you are today. They're moving this court to go ahead and grant what they're asking for in the complaint. So they're just moving on their complaint. Like we've complained, she's answered, we want our money because her answer is insufficient to say that we don't deserve what we're supposed to get under the contract.
Got it. Okay.
All right. So yeah. So I will dismiss for want of prosecution because they're not here, but I can't dismiss with prejudice because that's a procedural dismissal and it's not one on the merits of the case.
Okay. Can I ask you another question?
Yes, ma'am.
If I didn't show up, what would be the verdict from my end?
If you didn't show up and they did, because they're presenting the case, then they would get what's called a default because you didn't appear to defend. But if they're the ones who have to push the case. So if they don't show up to push the case, it's a dismissal for want of prosecution. If they show up to push the case, but you don't show up to respond to the case, then they get what's called a default.
Okay.
So that's how that goes.
Okay.
I do think, just to be super clear, Ms. Thomas did submit to the court a motion to dismiss complaint with prejudice. So I guess that would be right for the court to take up, but I don't know that there's sufficient, like you said, procedurally, I don't know that there's sufficient proof for that, just so that the record's clear.
So yeah, I'll dismiss for want of prosecution.
Okay. Thank you, Your Honor.
You're welcome.
Now that's you.
You're free to go at this time, Thomas. Thank
All
you.
right, y'all have a good day. Thanks.
All right, in Riverdale MHP versus Mortimer, since the defendant was not served and the information bounced back. So that case has been taken off the calendar. So if anybody was here for Riverdale versus Mortimer, you're free to go at this time. All right, so that is done. Mr. Richard, did I call your case and I missed it?
It's not on the calendar, Judge. I made another one of those errors. But he and Sierra Portis were scheduled to appear at the 11 o'clock calendar.
Okay, just send me the style, Miss.
Yes, ma'am.
Is it on the brief?
No, ma'am.
Okay, just send it to me. All right, I get Mr. Richard. Is my understanding that this is a dispossessory? Is that the case?
Is and
okay. Is it de novo from magistrate court or you filed it here?
I filed it here. The defendant answered on June the 16th, and Ms. Portis is on. She shows up on the Zoom. I don't think she's got her camera on yet.
I got you. So I have In Town Suites versus Portis. And then I have the, and you said you served it, she's present, and we're ready to go forward. And this is an original filing in state court, not a review of a magistrate court case.
Correct.
Okay. All right, sir. Ms. Portis, I'm gonna need to see you and hear you, okay?
I've been trying to turn on my camera. I'm on
Okay,
my
let me,
phone. I'm at work. I've been trying to turn it on.
hold on, let me, okay, I'm sorry. I'm gonna ask you to unmute. You'll see a prompt when you see that unmute. Okay, now I'm gonna ask you to start video with the prompt. And if you respond to that, it should probably help. You see what I sent you?
Yes.
There you go. Now, the screen is black. So you said you're on your phone?
Yes, ma'am, because I'm at work.
Okay,
I
hold
took
on.
a break.
I got you, but let me see if I can walk you through this. All right. So what I need you to do is to, do you see something that looks like an old-fashioned video camera down at any point on your screen?
Yes, ma'am.
Okay, click on that. Right next to that should be like a little up arrow. Click on the arrow, and it should allow you to go to your video settings. Because it looks like your video is not on.
Oh, hold on, Judge. I'm sorry. My daughter dropped my phone, so I'm trying. Yeah, hopefully.
Yeah, because it said it's playing video is playing, but it's just jet black. Do you have the camera up against something? Ms. Portis?
Judge, while Ms. Portis is working on that, this case was originally on our August calendar, so I did previously brief it, and I just emailed it to you.
Okay, no problem. Ms. Portis? Ms. Portis? Okay, maybe when she comes back, Mr. Richard, just give her a minute to come back in. Maybe she'll turn on her video from that point. And was there another case on this calendar? Because I see a Mr. Jones. Is Mr. Jones your witness, Mr. Richard?
He is, yes.
Okay, all right, then that makes sense. Mr. Ruff, I have you here. Are you on behalf of Ms. Portis, or are you here for something else?
Hey, good morning, Judge. I've been listening in the background. I sent you a text when I first logged on. It's actually about a criminal case, so I can wait to the end of the calendar. Not anything on your calendar this morning. If you want me to tell you, it's you did a plea on a traffic violation, and a woman was supposed to pay $300 plus court costs. Your deadline to pay was September the 29th, and she didn't have any money. She was panicked this morning that she was going to get picked up. So we actually asked Judge Spencer if she would place her on probation. So she got 12 months probation to pay the fines and fees.
Okay.
But that order was all signed, and I just wanted to make sure that you knew about it in case someone came to you and said, hey, this happened, and you weren't caught off guard.
As judges, we do each other favors. I appreciate Judge Spencer for handling that for me.
Thank you, Your Honor, for your time this morning.
No problem. Thank you.
And additionally, Judge, while we're waiting, the case where it was positioned for on the calendar, no parties appeared, Forest Park and Daniel Jackson, that was a motion to withdraw for plaintiff's counsel. Do you want to accept the motion to withdraw or try to reschedule it?
Well, nobody appeared, so I'll review the motion. I just don't like when motions to withdraw are filed and then the other party comes back and says, I never knew I didn't have an attorney.
Yes, ma'am. And we did serve plaintiff as well. So, but anyways, I'll send it to you.
Okay. Ms. Portis, I sent you the prompt to start your video now that you're back on. But really, Ms. Portis, there you are. All right, don't change a thing. Okay, now I'm going to ask you to unmute. Okay, do you see something that looks, there you go. All right, don't touch anything else. Speak, let me hear you.
Can you hear me?
Yes, ma'am. All right. So, Mr. Richard, you may begin. This is the case of In-Town Suites versus Portis. Ms. Portis is present. Mr. Richard is present. Mr. Richard has his witness present. This is 2025 CV 04223. Okay, go ahead, sir.
And Your Honor, if I could ask, do you have copies of the exhibits? We emailed them in earlier this week.
I do.
Okay.
Miss Powell just sent that information to me.
Okay, because I don't have the ability to share my screen on this particular device. So, okay.
That's okay.
So we're here for a dispossessory caused simply by Ms. Portis's failure to pay rent beginning on May the 15th. She was personally served. We filed the affidavit of service. She filed an answer on the 16th of June that doesn't assert any legal defense to the claim. It essentially pleads poverty. So we're prepared to put on our case. Should not take very long. I would call Mr. Jones. Mr. Jones, if you can unmute and raise your right hand. The truth, the whole truth, and nothing but the truth in this matter?
I do.
Okay. If you will look, sir, at Exhibit A, is that the guest registration agreement for Ms. Portis?
Yes.
Okay. And could you tell me your particular position with In-Town Suites?
I'm the general manager at the Jonesboro location.
And Ms. Portis resides there at the Jonesboro location, correct? Okay.
Correct.
And on Exhibit A, on the third page of that, there's a signature at the bottom. Can you tell me whose signature is that?
It appears to read Sierra Portis, but I'm not familiar with her signature. But yes, it is signed Sierra Portis.
Okay. And it's dated September 2nd of 2024. Is that correct?
That's correct.
Okay. And is this the agreement that governs In-Town's relationship with Ms. Portis living there at the property?
It is.
Okay. If you will turn to Exhibit B, and if you can tell me what that document is.
It is a folio with the room agreement. It basically is a description of all the charges that have been assessed on the room.
Okay. If you'll turn to page 5 of that document and go about a third of the way down the page, in the second column, you'll see dates. If you find May 15th of 2025.
Yes.
You see that there?
I do.
And does that reflect a room charge of $439.99?
Yes, sir.
And then right under it, a weekly technology fee of $14. Do you see that?
That is also correct. I see it.
Okay. And then in the next column over, it shows zeros for each of those entries, correct?
Correct.
And does that reflect that there were no payments received for those amounts as of the 15th of May, 2025?
That's correct. It shows that no payment was received.
Okay. Now, under those two entries, going all the way down to the bottom of the page, there are a number of late charges that are shown. Do you see that there?
Yes.
And In-Town has changed its policy on accruing late charges. Is that correct?
That's correct.
At this point, there are no actual late charges that have been assessed against Ms. Portis, correct?
Correct. And the ones that were assessed were removed.
Okay. And that removal, if you look all the way down to the bottom of that page, there's an entry on 6/24/25 for adjust late charge, correct?
Yes.
And that removes all the late charges that are shown between the 15th of May and the 24th or 23rd of June, correct?
Correct.
And is it accurate that the the fact that the late charges show up on this folio document is simply the product of the fact that InTown hasn't been able to change its computer system to affect the to reflect the actual policy of not charging late charges.
That is correct as well.
Okay. So the $439.99, that is a weekly rate under the guest registration agreement, correct?
Correct.
Okay. And the $14 is treated as additional rent under the guest registration agreement, correct?
Correct.
For a total per 7-day week of $453.99, correct?
That's correct.
Okay. And if you will turn for a moment to Exhibit C.
Okay.
Exhibit C, can you confirm this is the demand for possession that was sent to Ms. Portis, correct?
Correct.
And you'll see at the about a third of the way down the first page, it was sent multiple different ways. It was sent by FedEx. It was posted according to the landlord-tenant statutes, and it was emailed. As you look through this document, you'll see the actual email as well as the email receipt. You see that there at pages 3 and 4?
Yes.
And then right after that is the FedEx tracking information.
Yes.
Showing delivery to Ms. Portis.
Yes.
And then the very last page of Exhibit C is a photograph. Can you tell me, did you take this photograph?
I did take the photograph.
And what does that photograph depict?
It depicts a sealed envelope taped to the door with the room number on it, which matches the actual room number, which is the plate to the right of the door in the picture.
And was a copy of this demand for possession in the envelope taped to the door?
It was.
And was that taped to the door on May 27th, 2025?
It was.
And that was to satisfy the statutory requirement for posting that's shown on the first page of the letter, correct?
Yes, sir.
Okay. That letter at the bottom of the first page gives the statutory notice that the tenant, here Ms. Portis, had 3 business days from her receipt of the letter to pay all past due rent. Do you see that there?
I do.
Okay. And it mentions late fees in that statutory notice in the bold underlined language, but the late fees are included not because the late fees are included not because InTown was charging them, but simply because that's the statutory language that has to be included, correct? Mr. Jones?
I'm sorry, can you repeat that? I'm sorry.
Sure. At the bottom of page 1 of Exhibit C, in the bold underlined language.
Mr. Richard, I don't know that he's a competent witness to speak about what is legally required with respect to the statute, but you could go on. I got it.
Yeah, I'm simply trying to confirm that InTown was not charging late fees, even though the state's late fees.
Yeah.
Okay.
I remember our earlier late fee discussion.
Yes, we have done our best to fix that issue. Did Ms. Portis actually come in within 3 business days of her of the posting of this letter and pay any of the past due rent?
He did come in to discuss the past due amount and just to let me know that she at that time was still unable to pay, but that she was working on it.
Okay. And if we go from May the 15th in 7-day increments, we get to September 25th, which is the end of the last 7-day increment. the rent is paid in advance, correct? Under the guest agreement?
Correct.
So
Correct.
for 9/25, September 25th, that would cover a period through tomorrow, October the 2nd, correct?
Correct.
And there are 20 weeks from May the 15th to September 25th inclusive. 20 weeks times $453.99 is $9,079.80. Is that correct?
That is correct.
Okay. And the exhibits A, B, and C, are these documents that, particularly the folio, these are documents that are created with entries made at the time that rent is accrued and that payments are made by the tenant. Is that correct?
That's correct.
And these documents are relied upon in the conduct of in-town's business, correct?
Correct.
Okay. And you have charge of the guest agreement and the room agreement. You provided them to me, correct?
I did.
From the company's records.
Yes.
Okay. Your Honor, I'd move the admission of exhibits A, B, and C, and that's all I have for this witness.
All right, Ms. Portis, do you have any objection to the exhibits that he has shown the court?
No, ma'am.
All right, A, B, and C will be admitted without objection. All right, so Ms. Portis, Mr. Richard and In-Town Suites are alleging that you stopped paying rent on or before the 15th of May 2025, but you've still resided in the property since then, and your failure to pay has resulted in a rental amount owed of $9,079.80.
The paperwork I have says I only owe about 2,000, about 2,700 or something.
Okay, what paperwork
So
is that?
the exhibit I received in my email does not say anything about me owing them 9,000. What happened was I was having a hard time at work because they kept messing up my payroll, and that's why I was waiting on my check. But in the meantime of me trying to figure something out, he instructed his staff members to lock me out my room, and that's what started the whole process. I've been there in that room since September, but I've originally been at In-Town Suite since 2022. So after he started the paperwork, I just started to save my money, and I've been looking for elsewhere to stay. I just need time to find somewhere else to stay, but I told him that I was working on getting out his room.
Okay, so none of that is a legal excuse to not pay. You understand?
I do understand that it's not. At the time when my rent was due, they kept messing up my payroll at work. So when my rent was due, I didn't even have a direct deposit as of yet.
So they weren't paying you at all?
Yeah, I need.
So they weren't paying you at all?
Yes, ma'am, they end up paying me. It's just that it didn't line up with my due date. Cause
okay, but even
say
if
if
it
my
didn't
due,
lie, okay,
say
I
if my
got
due
you,
date,
Ms. Portis.
ma'am.
I got line up with your due dates, but did you pay at all? Like, did you make any payments since May?
No, ma'am. After I
Okay,
told him
so
that I couldn't.
okay, because what I'm asking is, you're saying I couldn't pay because I didn't have the money. But what you're now telling me is I didn't have the money when I was supposed to have it because of a problem with my job, but I did eventually get money. Now, when did you say he locked you out of your room?
That day that my payment was due, we have until 1 o'clock to pay, and then a late fee will occur on the account. And then after, I think at 5 or 6, that's when I guess they start trying to check the room out. But before 1 o'clock, he sent one of his maintenance men to my room to try to get into the room. At the time, I was on the phone in the room, and I put the little lock on the door, and I heard somebody trying to enter the room. And he said, "You need to go down there because I'm finna lock you out." So he tapped the key on the door. Once I guess he tapped his key on the door, it cancels out my key. So I went down to the office to talk to Lenny. So he already sent his staff members to lock me out of my room before the 1 o'clock late fee was even supposed to kick in. So that's what started it as well.
When was that?
It was sometime in May. I'm not even sure the date. Probably May 15th, like he mentioned, but I just know it was in May.
Mr. Richards, she's alleging constructive eviction.
If I can ask Mr. Jones, because it is in town's policy not to turn off any of the keys. In this instance, Mr. Jones, was Ms. Portis's key access to her room turned off? Was she ever locked out of her room after she failed to pay beginning on May 15th?
So the way the keys work, they cancel themselves out at noon on the seventh day. The guests are instructed to make a payment between 11 and 12 o'clock and that it's late at 12. Our system actually calculates the late fees at 1 o'clock. So I do send my staff to the room to see if they're going to make payment at that time. That's what my staff member was going to do, to see if she was coming down to make a payment. Him tapping the key on her room door is so he can access the room to see if someone has vacated the room already, because sometimes we have people check out without notifying us, and that's the only way we'll know, by going by the room. But she did come down to the office and instructed me everything that happened, and I processed her key for her without payment. And then when I realized that she wasn't going to be able to pay any longer, I went ahead and processed her key without payment for 30 days, which is the process we do while we're waiting an eviction.
And that process of renewing the key for 30 days or more continues throughout the entire period that an eviction is pending before we get to an eviction action is pending before we get to an actual eviction by the sheriff. Is that correct?
Correct.
That is not what happened.
Okay, did they reinstate your key, Ms. Porter?
What ended up happening, Judge, was after I was locked out of my room, because I know the policy from the previous manager, I had to call the police because I was locked out of my room. The police instructed him that since I've been there longer than, I think, 90 days, he can't legally lock me out. So after that, he ended up activating my key for 1 week. The next week, I did have to come in and ask him to activate it again. He activated it for 1 week, and after that, that's when he started activating it for 30 days. He didn't immediately activate my key for 30 days, and he wasn't going to activate it if the police didn't say that he couldn't lock me out.
Yeah, objection, speculation.
Okay, so here's the issue. You got a good case for eviction, except Mr. Jones's actions would constitute an illegal eviction.
I do understand that, Judge.
Hold on, Ms. Portis.
Mr. Jones testified that she always had access to her room, that her room key was renewed. It's not Mr. Jones, the key itself. Yeah. Is this a physical key that goes into a lock, or is this an electronic key card?
It's an electronic key card, and we actually gave her access to I don't remember the police coming for her particular case. They have been here before for other people. She is familiar, like she said, she's been there for several years, so she's familiar with the process of us trying to remove tenants from the property without payment. And in some cases, we do have to call law enforcement to get people to move. And in some cases, I, being a new manager here, haven't always known how long the tenant has been there. And once we look at the record and find out they've been there longer than 30 days, the police do ask us to renew the keys. So she's aware that that has happened as well. But on that particular day, I actually had them open the room for her because she said she had to go to work. So she's always had access to the room. She said, when I get off work, how do I get in without a key? And I said, I will make sure the night attendant allows you to come in your room when you return. She's like, well, this can't keep happening. I can't keep calling the office to get in the room. You're going to have to make me a key. And then the next day I did make her a key.
But in the meantime, she did have access to her room, correct?
She's always had access to the room.
Is it simply a process of renewing the electronic key card?
Yeah, but he said, what he's saying is he didn't renew the key. He told her she had access by going to the desk and asking the person at the desk to allow her into the room. It wasn't until the next day that he made her a key so that she would have unfettered access to her property.
If I can clarify that, the key card has to be physically present in order to renew it, correct?
Correct.
So she wasn't physically present with the key card in order to renew it on the first day. That's why you told the night attendant, because she was at work.
Right.
She needed to come back, talk to the night attendant to get in. Until she shows up with the physical key, we can't renew it. Is that correct?
That's correct.
So, Ms. Portis, you are, so 20 weeks at $453.99. They've removed all.
Judge,
Yeah.
I think she's dropped off the Zoom. She was there a second ago and then the screen changed.
Okay, I hope she comes back because I don't think her I don't think it was the best audio or Wi-Fi. In the courtroom, did the interpreter come to speak? And was that Miss Figueroa, Gloria Figueroa? So deputy in the courtroom,
yes, Miss Fitzgerald came and spoke to her. She advised her she needed to speak with her attorney.
Okay. All right.
Also, Judge Miss Gardner is on the case. She is the attorney in the in position 4.
Position 4 for which one? Which case?
That was the motion to withdraw, and it is Forest Park versus Daniel Jackson. But
Okay,
the motion specifically is between plaintiff and plaintiff's counsel.
Okay, okay.
PNC National.
Who's the
Oh, you're here for PNC National Bank, Miss Gardner?
Yes.
I totally misread that. I'm sorry. Okay, position 5, PNC National Bank. Justin Brown, and Justin Brown never appeared either.
All right. So, Miss Gardner, what happened? Why weren't y'all here?
I apologize. My internet, they're doing work outside and my internet went down, and I apologize profusely for being late today.
Because I issued a dismissal for warrant of prosecution on that case when I called the calendar.
Yes, we have a pending motion for summary judgment, and the defendant has not responded.
I know what was pending, but when I called it for the calendar, you didn't appear. So at that point, I issued a dismissal for warrant of prosecution. And you said that it was because you had internet issues. Did you let Ms. Powell know?
No, actually, all of my power went out. So I apologize. Nothing else I just apologize to the court.
All right. Mr. The Jackson, I guess, no, Justin did not appear. This is PNC Bank, correct?
Yes.
All right. All right. So hold on, I'll let you I don't know what's going on with Miss Portis. I get the impression that Miss Portis knows that she And she says she's been saving her money to leave. Mr. Richard, you made the case for an eviction. Did you want judgment in the amount of $9,079.80 plus writ of possession?
Please, would you like me to prepare orders?
Yeah, because she appeared and because she answered, we'll give Ms. Porter 7 days to vacate.
It looks like she's coming back on now.
Oh, okay, good. Ms. Portis? All right. So Ms. Portis,
Yeah, I'm sorry, Judge. I'm sorry, everybody.
I got you. I get the impression that you understand that you can't stay in the property without paying. You've been in there since 2015, since May 15th of 2025 without making payments. You said that you're saving your money in an effort to go somewhere else, but you can't remain indefinitely in someone's property if you're not paying. You only get to possess the property if you're paying for the property. And in this case, it's been 20 weeks at the latest for $9,079.80. The court can give you 7 days to vacate, but that is the most I can give you legally. You can negotiate with them for more time, but I think it's been 20 weeks since they've been paid. So I don't know how that negotiation would go. But at this point, the court is going to issue an order for a judgment in the amount of $7,079.80 plus court costs plus 7 days to pay. Now, I get that times are hard, ma'am, but you can't stay in people's property and not pay. Like that's the first responsibility for a tenant is to pay on time the full amount every time. Okay. All right. So you'll get a copy of the court's
Judge,
order. Yes.
You when Mr. Richard was proving his damages, you followed and got the 9,000, right? Because the exhibit that was admitted shows a balance of 2,700 and some change, and I just want to make sure that you caught.
No, I followed what he presented from May.
Okay, and you got to the 9,000.
Yeah.
Okay.
Yeah, Your Honor, if I may, what you just mentioned as you read it out was $7,079.80.
Did I say 7,000?
You did.
I'm sorry, I meant 9,000. I have 9,000 on my paper. It says 9,079.80. So I was probably just talking too fast. So Ms. Portis, unfortunately, it's going to be 7 days. If I were you, I would just, as soon as I get back home, start preparing to move so that your things are not set out, because once they get the writ of possession, they can go seek an eviction from the sheriff's office. Okay. All right, ma'am. I hope things go better for you. Okay. All right. Take care.
Your Honor.
Yes.
You enter the writ of possession on the complaint form, and I'll simply submit.
Yeah, that's fine.
Order for the. I'll submit a proposed order for the money judgment, but the form already has the writ of possession right there.
Yeah, that's fine. No problem.
Okay. Thank you very much. May I be excused?
You may. All right, Mr. Jones, Ms. Portis, you may be excused. Ms. Gardner, hold on a second. Okay, so Ms. Gardner, you're here for PNC Bank versus Justin.
Yes, Justin Brown.
All right, so this is 2024 CV 04560, PNC Bank versus Justin Brown. Mr. Brown did not appear when I called the case earlier. Ms. Gardner, on behalf of PNC Bank, is here. She alleges that she had technical difficulties and was unable to log on initially. Go ahead, Ms. Gardner.
Plaintiff has filed a motion for summary judgment. The defendant opened a credit card account with PNC Bank, defaulted on the account by failing to pay as agreed. The principal amount owed by the defendant is $5,089.29. Defendant did file an answer that is a general denial based on the brief memorandum of law and the exhibits submitted with plaintiff's motion for summary judgment. Plaintiff states there's no genuine issue of material fact and plaintiff is entitled to judgment as a matter of law.
And PNC Bank is the original debtor, not not an assignment.
That's correct. PNC is the original.
Yeah. Okay.
That's correct, Your Honor.
All right. So you're seeking $5,089.29 plus court costs.
Yes, Your Honor.
All right. So the court will grant that if you'll submit an order, unless we already have one.
Thank you so much. And I apologize, Your Honor.
No problem. You look like you're having a worse day than I am. So I hope things get better.
Thank you.
All
Have a
right.
great day.
You too. All right. So that concludes the 11 o'clock calendar, the 10 o'clock calendar, we have a 1 p.m. calendar, and the court will be back for that. But I wanted to, I guess, Miss Figueroa or whoever that was in the courtroom stepped out. So we'll be back at 1 p.m.
Judge, before you, can we hang back?
Hold on just a second.